you. Thank you. You all are too kind, way too kind. I'm Mark Barnes, and this is your annual edition of the Hot Topics in Employment Law. It's our Halloween edition, so we have lots of scary law for you. Unfortunately, this year I cannot attend in person, so this year I'm bringing you the hot topics via satellite. Marijuana! Marijuana remains a hot topic in employment law in Ohio, unless you've been stuck in the Ohio caverns smoking weed for the last year. You know that Ohio enacted a new medical marijuana law. The law will officially go into effect on September 8th, 2018. However, over the course of the last several months to a year, the State Medical Board, the Board of Pharmacy, and the Department of Commerce have all been working diligently to put together the rules that will support the law, and all of this went into effect effective September 8th, 2017. So, now that we have some new rules and they're in place, here to talk to you about her experience with the new medical marijuana laws, or rules, is my crazy neighbor from next door, Mary Jane. Mary Jane, why don't you tell us about your experience with the new rules?
Well, Michael Che.
Oh, I'm sorry. I'm not Michael Che. Michael Che is the host and anchor of Saturday Night Live's Weekend Update. This is the Hot Topics in Employment Law. I'm Mark Barnes.
Yeah. So anyway, Michael, so you asked about the marijuana laws. So I think these rules are confusing and ridiculous. You know, so Billy Bob, you know Billy Bob, right?
No.
He's my cousin's cousin. He wrote me a script for weed. And I've just been dying to smoke it. So last week, went to work, took my blunt, lit up on break. And not only did my boss take my weed, but he fired me. I mean, I'm, like I said, confused. What the heck? I thought this stuff was legal now.
Well, Mary Jane, you are aware that you can't smoke marijuana under this medical marijuana law in Ohio, correct?
Wait, what?
You cannot smoke medical marijuana in the state of Ohio under the law. You weren't aware of that?
Oh, what else are you going to do with it?
Well, there are lots of different forms in which you can use medical marijuana. You can use it as a patch, or a tincture, or an oil, an edible. You can actually use the plant material to vape it. But you know, vaporizing and smoking are two different things.
Thank God. Well, I'm still confused. I mean, because you can smoke in Michigan, so I'm still very confused. I mean, you can smoke in Michigan, I go to work in Ohio, you know, you got the virtuosity thing going on, right?
I'm sorry. Virtuosity?
Virtuosity, you know.
You mean reciprocity.
Virtuosity.
No, it's a different word, reciprocity. Well, look, the Board of Pharmacy is supposed to be putting together agreements with other states, okay, whereby you can, you know, reciprocity agreements, whereby you can use medical marijuana. However, the eligibility requirements in the other states have to comply with Ohio law. And so these reciprocity agreements, they're not in effect yet. All we have are the rules. So, yeah. So even though you might be able to smoke it in Michigan, you can't do it here.
Guess I shouldn't leave Michigan.
Maybe not. So, well, let me ask you this. Who prescribed this medication for you again?
Billy Bob.
Billy
My
Bob.
cousin's cousin. I told you that.
Right. And he's a doctor, right?
I don't know. I mean, he's my cousin's cousin. I don't know. I don't think he's a doctor, but, you know, he's family. But family don't examine, so,
There has to be a bona fide doctor-patient relationship in order for you to get a script. So
it's a relationship, and I got a script.
And then also the doctor has to be registered with the program. Is Billy Bob registered?
Registered as in Secretary of State, driver's license, of course.
No,
Registered.
no, registered with the program. Are you registered?
Do I have a driver's license?
Well, that's a start.
I have a driver's license, yes, I'm registered with the Secretary of State.
Okay. Is your license in Ohio or Michigan?
Michigan.
Of course, of
You're
course,
right.
of course. Well, let me ask you this, Mary Jane. What medical condition is it that you're trying to medicate anyway? Is it like ALS or MS or PTSD, cancer? I mean, what is it?
Orgophobia.
What does it mean? What is that?
It's the fear of being at work.
Fear of being at work. Okay, well, you know what? I don't think that's a qualifying condition, and yeah. Anything else, Mary Jane?
Well, they still can't fire me, right? I mean, I had a script. They can't fire me. There's that case out of Connecticut, California, Connecticut. It's Connecticut. I remember now. You cannot be fired for using medical marijuana.
You know what? Unfortunately, we're not in Connecticut. I hate to break it to you. This is Ohio. We're in the Midwest, and under our medical marijuana law, your employer absolutely can fire you for using medical marijuana while employed. So, well, I tell you what, Mary Jane, it has been a blast. Thank you for coming on the show. The news is too voluminous to address in this segment. Here are some of the highlights. To qualify for placement on the medical marijuana registry, a prospective patient must establish and maintain a bona fide relationship with a recommending physician who shall submit a complete registration. Receive a diagnosis of a qualifying condition from the physician. Consent to treatment with medical marijuana. The patient must pay the board its pharmacy fee, and patients also must have proof of Ohio residency, unless they are authorized pursuant to a reciprocity agreement. Of note, patients can only buy a 90-day supply of medical marijuana and are not permitted to accept free samples of the medication. Physicians are also required to obtain certification to prescribe medical marijuana, which in turn requires the doctor to, 1, be free from disciplinary action, 2, have at least 2 hours of continuing education regarding diagnosis and treatment of medical marijuana, have a bona fide doctor-patient relationship with the individual prescribed medical marijuana. There must be documentation of the patient's current medical condition and that it is a qualifying condition, and documentation that standard medical treatment has been attempted or considered and is not appropriate for the patient. This is not an exhaustive list, but should give you a flavor for what the medical marijuana rules require of doctors and patients. During the interview with Mary Jane, she brought up the fact that there is a recent case which found an employer improperly terminated an employee who was using medical marijuana. This case arose in Connecticut, where the state's medical marijuana law prohibits discrimination against employees who use medical marijuana. A federal judge found that federal laws such as the ADA, the Controlled Substances Act, or the Federal Food and Cosmetic Act have no effect on such a state law. So what does this mean for us here in Ohio? Nada. In other news, the LGBT community scored a major victory in employment discrimination jurisprudence. For the first time, a federal appellate court held that a person who alleges discrimination in employment based on his or her sexual orientation has set forth a legally cognizable discrimination claim under Title VII of the Civil Rights Act of 1964. In the case of Kimberly Hively versus Ivy Tech Community College of Indiana, Ms. Hively alleged she was being prevented from a full-time teaching position because of her sexual orientation. After filing a lawsuit in federal district court, the school moved to dismiss the case on the ground that Ms. Hively's suit failed to establish the school discriminated against her because of her sex, arguing that sexual orientation and sex are two different things. Title VII prohibits employers from discriminating against individuals because of race, color, religion, sex, or national origin. The district court granted the school's motion and Ms. Hively appealed. The Seventh Circuit heard Ms. Hively's appeal en banc, meaning that all 11 judges on the panel heard the appeal. The court acknowledged that almost all the federal courts of appeals have declined to apply Title VII to sexual orientation, including the Sixth Circuit. In fact, the Seventh Circuit itself had previously found Title VII did not cover sexual orientation. Nevertheless, the court overruled its precedent in this landmark decision. Considering the United States Supreme Court's decisions in Loving v. Virginia, a landmark race discrimination case, United States versus Windsor, which struck down parts of the Defense of Marriage Act, and Obergefell v. Hodges, which found same-sex marriage is protected by the U.S. Constitution, the Seventh Circuit found it would require considerable calisthenics to remove the sex from sexual discrimination. In some part, the Seventh Circuit's ruling may have been influenced by the position taken by the EEOC, which is that Title VII protects sexual orientation. By contrast, the Justice Department, under President Donald Trump's administration, has stated the position that Title VII does not protect sexual orientation. In fact, the DOJ recently filed an amicus brief stating such position in a case called Zarda versus Altitude Express, which is currently pending before the Second Circuit, and the EEOC filed a brief in the same case saying just the opposite. The full Second Circuit heard oral arguments on September 26, 2017. But here's the rub. Both agencies, despite their conflicting views, play a role in protecting against discrimination. This is sort of like when you ask your mom if you can go to the prom and she says, sure. And then you turn to your dad and he's like, hell no, you can't go to the prom. And you're like, damn, I wish recreational marijuana was legal. It's confusing. I know, it's weird, and it doesn't make any sense. But there are other things in this world that don't make sense either. Like, why do I have to give somebody 10 feet of space at the ATM? Or why do middle-aged men have more hair in their ears and noses than they do on the tops of their heads? Or David S. Pumpkins. Anyway, last year this time, we spoke to you about the new overtime regulations, which were going into effect December 1st, 2016. Funny how much changes in a year. Now everything we told you last year about the overtime regulations is a nullity, like it never existed. Sort of like Andy Dufresne when he escaped from Shawshank prison.
Lord, it's a miracle! Man up and vanished like a fart in the wind.
But seriously, no, really, seriously, you may recall that a number of states sued the Department of Labor challenging the final overtime rule, and then moved for an emergency preliminary injunction, which the court granted. The Department of Labor then appealed the decision on the preliminary injunction to the Fifth Circuit. On August 31st of this year, the court entered its final decision, finding that the overtime rule is unlawful. Under Section 213A1 of the Federal Labor Standards Act, employees are exempt from overtime if they're employed in bona fide executive, administrative, or professional capacities. In 2004, the department adopted two tests to determine exempt employees: the duties test and the salary basis test. Until the recent overtime regulations, the minimum salary under this test was roughly $24,000. Federal District Court Judge Amos Mazant found that the overtime regulations increasing of the minimum salary to nearly $50,000 rendered the duties test a virtual nullity, as if the duties test never existed. You know, sort of like Andy Dufresne.
Man up and vanished like a fart in the wind.
According to Judge Mazant, this is not what Congress intended. On September 5, 2017, the Department of Labor under the Trump administration moved to withdraw its appeal. At this point, it is unclear where the overtime rule is headed. Prior to Judge Mazant's ruling and the withdrawal of the appeal, the Department of Labor published a request for information for the overtime rule. The public comment period ended on September 26, 2017. These have been your hot topics, the Halloween edition. Ooh. In my absence, Carl Habekost, Dana Quick, and Tybo Wilhelms will be happy to field any questions that you may have, as I now must head to another assignment. Is the mic off?
Yep.
All right, good, because I'm going to be late. I got to get out of here, get some practice in before I start this thing.
Whatever you do, don't get the club caught in the skirt.